I would like to welcome everyone very warmly on behalf of the Centre for Commercial Law and Regulatory Studies at Monash Law School for today's Law and Business seminar. I also wish to acknowledge the traditional custodians of the land from which I'm calling, and I pay my respects to elders, both past and present, and extend that respect to other Aboriginal people who may be participating in this event. So today's seminar is on the topic, the long-term effects of short selling and negative activism. An American historian, a legal historian, Stuart Banner, has said that throughout history in Anglo-American popular culture, there has always been a strand of thought that was suspicious of trading and hostile to speculators. And short selling certainly exemplifies this historical trend. From the 17th century, it's sometimes been described as immoral. And I think in your paper, Frank, you talk about short sellers being the sworn enemy of management. So there's this very negative view of short sellers in some areas. But it was during the global financial crisis in 2007 to 2009 that tensions between short sellers and regulators really came to the forefront. And we had a wave of international regulation, including in Australia, designed to control short selling. Short selling is again a hot topic as we enter into the era, or maybe we're halfway through the era of shareholder activism. And we are delighted to welcome today our speaker, Professor Frank Partnoy, who is the Adrian A. Cragen Professor of Law at UC Berkeley School of Law in San Francisco. I recently described Frank in a LinkedIn post as inimitable, and that really is an understatement. He's a renowned teacher and scholar. He's also a media personality, and before he became an academic, he worked in the real world as a lawyer at Covington and Burling, and he did fixed income derivatives specialization at Morgan Stanley and CS First Boston. Frank's going to speak to us for around 30 minutes today in presenting his paper, and he'll be then followed by our commentator today, Tom Weidners from the Australian Securities and Investments Commission. And Tom's going to be providing us with a perspective from Australia and from an Australian regulator. So Tom's had more than 30 years experience in financial markets, and he started his career on the trading floor of the then Australian Securities Exchange. He moved into market surveillance and compliance roles with the ASX and Credit Suisse, but for the last 15 years, he has worked with ASIC, where he leads ASIC's equities market surveillance team, responsible for digging out serious market misconduct. So welcome to you both, Frank and Tom. We're so delighted and pleased that you're able to be here with us. Just if I could tell the audience before we get underway, we will have time, I hope, for questions and some discussion with our speaker and commentator after the presentations. And so please, as we're going through, feel free to put any questions you may have into the Q&A box. And if you could just identify yourself and the organisation that you're from, that would be terrific. And so then we can go to those questions later. So at this point, I'm going to pass over to our speaker, Professor Frank Partnoy. Over to you, Frank.
Thank you so much for the kind introduction, and hello to all of you. Those of you who know Professor Hill know what a force she has been in law and business, both in terms of her intellectual horsepower and her convening ability, and her ability to bring together practitioners and academics to discuss important issues. And I've been a beneficiary of her wisdom for many years. And so I'm thrilled, Jennifer, thank you for including me. And Tom, we were speaking briefly earlier. I'm excited to hear your perspective and to gain your wisdom as well, given your practice and regulatory experience. I think it's especially appropriate to have you, and I'm looking forward to our conversation. So welcome everyone, and thanks for including me. As Professor Hill mentioned, this is a hot topic, and I think an interesting topic. And so I'll just give you the punchline right out of the gate. So I have a paper with Professor Peter Molk at the University of Florida's Law School. And again, the title, as Jennifer mentioned, is The Long-Term Effects of Short Selling and Negative Activism. And so we're focused on short selling, in particular, activist short selling. I'll talk about this term negative activism in just a second, but the punchline of our story is that short selling and negative activism has real and long-term effects. So this is a follow-on paper to a previous paper that we did with Barbara Bliss on short selling and negative activism. And the point here is that these short sellers who intervene, the negative activists, have not only a short-term impact, but they have a long-term impact. It's not just temporary or it's artificial. On average, the share prices of targeted companies fall by more than 20% after 4 years. Their accounting returns plummet. Targets are more likely to be sued. They're more likely to be investigated by regulators. The numbers are staggering. And we were excited to find this and interested to explore the implications of this. So again, these are short sellers. They're betting against companies. They make money when the companies are destroyed, when their stock price goes down. This paper shows that not only do they have this impact in the short term betting against companies, but they have that impact in the long term. So those of you who aren't familiar with short selling, the mechanics are a little bit strange. You borrow stock and then you sell it. And so let's say you get $100 for it. Well, you've borrowed the stock, and so you make money if the price goes down. So you can buy the stock at a lower price, redeliver it to satisfy your borrowing obligation. If the stock price goes up, that's when you get creamed. And one of the things that we've seen recently is a lot of short sellers getting creamed. And so the short selling business and short selling in general in the rising markets globally has been a tough business, and I'll talk a little bit about that. In terms of this paper, we weren't sure what we would find when we looked into this data set. Our previous research had shown, as I mentioned earlier, that there was a short-term reaction to these short sellers, to the announcement of, quote, negative activism, and that negative reaction was in the range of 7%. Stocks went down in the short term 7%. And some people reacted to our initial research saying, well, maybe it'll bounce back, maybe that's just manipulation. And so we wanted to study what the longer term impact was in this paper to try to address some of those questions. And just at the outset, before I get into the main issues, this finding of the share price going down so much for so long is really puzzling. And I think it's important for policy to recognize that it's puzzling. So in other words, the short-term reaction, this minus 7%, isn't reflecting everything. It isn't reflecting all of the information. If you think that markets are efficient, there's something going on that's puzzling in that the stock is going down, but it's not going down by the full amount. And that's important for policy. It shows that short sellers really are doing something. They're providing information, they're finding bad companies, but it might also be that what they're doing in their interventions is itself bad for companies. And so that's one of the puzzles. And as Jennifer said, these are often unpopular naysayers, people who have been vilified in history. But the basic point in this paper is, we like you if you're a short seller. We like you. We used to like you just in the short term. Now we like you in the long term as well. And when we wrote the paper, it was partly in response to the GameStop Reddit-driven stock appreciations, and there were regulatory debates around that. But now there's still a number of policy initiatives globally where we hope that this will help inform the debates. Okay, so that's an introduction to the topic, and what I'm going to do in my remaining time is just go through the three pieces of the paper. So you don't have to read the paper. I'm going to give you the details, and I'm not using any PowerPoints, so periodically I'll just ask you to imagine a graph, but I want to try to keep it intuitive, because intuitively it's somewhat surprising that you'd have these professors saying it's good for people to bet on the downfall of the economy, or it's good for these short sellers to win when they bet on companies being destroyed. But the basic answer here is that they're finding good information. So Luckin Coffee and Wirecard, and there have been numerous frauds involving companies, and we want to know that. That's the basic point. And short sellers help us learn that. Okay. So the three things I'd like to go through are just some background on the gaps in the literature. For those of you who aren't that familiar with the literature on activism and short selling, I'll give a little bit of background first. Second, I'll go into some of the specifics of our empirical findings and talk about the data set that we used and what specifically we found. And then finally, I'll talk about some policy implications to what it is that we found. So first, let me just start off with some background. So we call this negative activism. So those of you who haven't thought about this term before, you might say, well, hold on, if it's negative, what's positive activism? So that's a good question. And this didn't used to be called positive activism. We've kind of tried to rebrand it, but shareholder activism generally is something that scholars have been investigating for the better part of 2 decades. And Professor Hill has talked a lot about this. Our friend Randall Thomas and I have looked into these questions. And so I spent a lot of time investigating what we'll now call positive activism, but which is shareholder activism at companies where the shareholders are taking long positions, not short positions. And this has been increasing in terms of the number of activist interventions and also in terms of academic study of these kinds of interventions. And I wrote co-authored a number of papers in this area, and even posed as a shareholder activist briefly myself, targeting a company called Tejon Ranch, and co-authored a lengthy piece in the Atlantic magazine about my experiences. But in terms of just background, by way of the academic literature, it basically went in 2 steps. The first step was to look at the short-term impact when a shareholder activist intervened, and second, to look at the long-term impact. So the short-term impact, there were several papers in the 2008 range that showed that when shareholder activists, these are, again, positive activists, people who are acquiring typically 5 to 10% of a company, and then announcing that they intend to intervene to try to improve the company, that when that announcement happens, that it's associated with a positive 7% return, abnormal return above market or index. And it's kind of curious to me that that is plus 7%, which was discovered in 2008, replicated repeatedly since then. And then the negative activism, negative return is the mirror of that, minus 7%. I just think that's kind of cool. You know, in law, we often think that we're just debating policy and these kinds of ephemeral questions, but this almost seems like it's science, or that there's something real underneath this, that the plus and minus signs are both on top of a 7%. But that 7% created a lot of interest and led activists to be able to raise huge amounts of money, and also generated almost an entire field of study, really, that is the backdrop for studying negative activism, the mirror image of positive activism. The negative activism literature followed that same kind of first burst of activity, looking at the short term. And then in the second phase, the long positive activism researchers started looking at the long term. And there's a debate in the literature about what people think about the long term, but essentially we wanted to try to track that. So to try to do the same thing in the literature that other scholars did for long-term positive activism, to look at long-term negative activism. And essentially there are 2 narratives here, just again, by way of background. One is that the short sellers are good for the markets because they generate information. And there are a lot of studies that show that when you restrict or ban short selling, that can have a negative impact on informational efficiency in markets. And I think it'd be fair to say that if you were to poll most finance academics, they would be pro short seller, and they would be against restrictions on short selling. And so that's one camp that has emerged, again, just by way of background. The other camp is very, very different. These are people who think short sellers are manipulative and evil. And Elon Musk is in this camp. A lot of regulators in the US have historically been in this camp, although often are resisting the impulse to regulate. And then I'll let Tom talk about Australia, but European regulators also have been, at least in their rhetoric and sometimes in policy, very much anti-short seller. And then politicians love to flog short sellers and blame them for problems, as obviously do managers of companies, especially when they're targeted by short sellers. So that's background. Rather than just making arguments about short sellers and negative activism, we decided we would hand collect a bunch of data. And so that leads me to the second part of my talk, which is the empirics and what we found. So when Randall Thomas and I did a similar talk for Professor Hill a long time ago now, we showed a photo of us down in a cave exploring. I don't know if you remember that photo, Jennifer, but we view ourselves as explorers, very much looking for data. And Peter Molk and I, first with Barbara Bliss and then more recently, investigated and hand collected a lot of data. So let me just shake off if you're tired now, if you haven't had enough coffee, shake this off, and I'm going to do some data for you now. But I hope it'll be sufficiently interesting that you'll stay interested. And as I said, I'm not going to do any charts. So I'm just going to ask you to imagine some numbers. Okay, so the data set that we looked at, and I'll talk about some of the critiques of the data because they're subject to critiques. But the data set is called Activist Shorts Research. It's a publication that sets forth reports of short sellers who engage in an activist way. Again, remember this word activist. It's not just that you're short selling, it's that you're short selling and trying to do something to the company. And typically, the thing that you're doing, we call informational activism, meaning that what you're trying to do is to publish research or other information that shows that this company is not as valuable as it actually is. And I think it's important to distinguish that kind of informational activism, which is most of what we're finding in our database, from a much more problematic kind of activism, which we label operational activism. And the idea of operational activism is that you take a short position and actually try to destroy the company. So Elon Musk has accused people of engaging in industrial sabotage attempts regarding his companies. There was a short seller event that involved blowing up a bus of a publicly traded German soccer team. These are events that make good novel plots or films, but are not all that common. And most of what's in the database that we're looking at does not include this kind of thing. It's mostly just short sellers who think companies are overvalued. And so they're publishing information. They get on Twitter, they say, hey, we have this report. We think this company is overvalued. And so we look at this activist shorts research database from 2019 through 2016. And one of the reasons that we stopped in 2016, this article was published this year, but we wanted to have 5 years worth of data to look at the long-term effects of these interventions. So we're looking 2009 through 2016, so starting just after the collapse of the financial markets and then going through 2016, where we have 5 years of data. And we looked at 825 of those cases. And we found that -7%, again, it's replicated elsewhere in the literature as well. So on average, in these cases, stocks go down in the short term by 7%. But the cool stuff that we're excited about that we will share with you today is what we found when we hired, or actually Peter Molk hired an army of research assistants to go through a bunch of databases, including litigation and news databases, to match up the suits with the lawsuits with other data, and to give us a deeper picture into what has happened in the long term after these interventions. And this is kind of these are the big new findings to the extent there's new stuff in this paper. Okay, so first, so again, I'm in my second, trying to keep track of where I am here. My second part, is everybody with me? In the second part of my talk, we're going through some of these details. So the big finding on returns, if you imagine I'm showing you a stock price chart, it's a stock price chart that goes up a little bit at the beginning and then plummets, just goes straight down, 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 down for 4 years. And we parse the data in various ways. We run robustness checks, 20% down on average. And one of the interesting things about the findings is that the stock price of these targeted firms goes up early on. And part of that is likely because short sellers are waiting for an opportunity to short after the stock has gone up. But in some instances, it's the short sellers are really fighting against the media and in some cases, manager efforts to put out positive information so that the stock price goes up and the short sellers have to unload their positions. And that's a lot of the Reddit GameStop type phenomenon to blow out short sellers during that early phase. But we find significant long-term negative performance by companies targeted by activists. And again, this is not reflected in the initial share price. So these are surprise declines, or at least probabilistically not anticipated declines. So the magnitude of that initial share price decline triples during the following years. So if you do look at the paper, it's published 2022 Illinois Law Review, you'll see chart, down, down, down. Buy and hold returns, calendar time portfolio regressions to minimize cross-correlation, the stuff that you'd expect to see in a robust finance academic setting. There's no way we can beat this data to make that effect go away. So we think that result is very interesting. We don't know whether people have been taking advantage of this by trying to hold long-term negative positions after short activists intervene. And many people accuse the short activists of being very short-term in focus. One of the implications of our paper is that that would be incredibly irrational if that's what they're doing, getting out of their positions too early because they can earn negative 20% for 4 years. We also look at operational performance metrics. We look at return on assets and show no real difference in terms of return on assets during the year before intervention, but future years are either negative or no sign difference. And then notwithstanding the fact that I have several papers with Bobby Bartlett at UC Berkeley disparaging the use of Tobin's Q, we feel obligated to at least report the statistics for Tobin's Q, showing the punchline that if you happen to use that, which we recommend that you not use because of something called the ratio problem, where the denominator can be correlated with one of your right side variables. And I just saw 8 people fall asleep as I said that sentence. But the basic idea is that Tobin's Q can be quite dangerous, and we've written about that at great length. But nevertheless, people use Tobin's Q, so we threw it into this paper. And it also shows that if you do that and do it the right way, there are negative operational implications. And we give a bunch of examples too, if you aren't persuaded by the numbers. What's interesting is that many of the prominent examples that are featured in the paper are either they're individuals who are no longer in the business, or they're individuals who have received subpoenas from the Department of Justice in the United States and are under criminal investigation. And if you've been following the recent news with Donald Trump, you know it's non-trivial to get a subpoena for a search warrant and a judge signed off on there being probable cause with respect to this short selling investigation. So even though our paper suggests it's a very happy time for short sellers, the recent events in the last couple of years show that it's not so happy. Just in terms of the data, we also show that there that there is a strong association between negative activism and lawsuits. So securities class actions are what we're looking at in particular, and we give so a lot of tables with granular details about these effects, and even some league tables of the impact of different plaintiffs' law firms. But basically what we did is in matching up the short activism with litigation, we found 84 class actions that matched up in our database that we could connect to earlier reports. And one of the things that jumps out is that the lawsuits are referencing what the short seller said. And our view is that many of these lawsuits would not have been brought without the negative activists' work. So Citron and China Valve's technology, stock price drops 18% when it's announced, there's negative activism, and then a month later, there's a lawsuit. And that lawsuit does well. These are lawsuits that succeed. So whatever you think of class action litigation, you might want to reform it, but even if whatever your view is, what we're showing is that there's a tie between the negative activist and the litigation. We find direct quotes from the negative activist reports in the class action suits. And so here also there are some charts. And again, it's easy to imagine what the charts are. I don't need a PowerPoint slide, just imagine the stock price going down. So the stock price goes down when the lawsuit's filed, and then the stock price goes down even further. And these are large, statistically significant drops. We go into a lot of detail about the litigation. A lot of these lawsuits are dismissed voluntarily by the plaintiffs' firms, which is interesting. I'll just highlight one aspect of the litigation, which we found particularly interesting, because it's often thought that when there's a meaningful stock price decline, there will be a lawsuit, right? This is kind of the typical story in the US. The stock drops 10%, the plaintiffs' firms all circle, and they file litigation. And one of the things that we found that was very surprising was that there are a lot of very significant stock price drops after short sellers make their announcements that nevertheless don't lead to litigation. And the one that was the most surprising was that even when there's a 20% stock price drop, which that's as much catnip as you could load up for plaintiffs' lawyers, a 20% drop, only 44% of those actually generate lawsuits, and that seems very low to us. Why wouldn't you sue? Why wouldn't you be really revved up and excited? So that's one part of our empirics. And then I'll just mention one other, which is regulatory action. And this might be the one that's maybe the most interesting to Tom, but there's a similar story for regulators. We were able to match up, again, with the help of our research assistants, 39 regulatory actions that likely would not have occurred but for the short sellers. And we see this as a good thing. In other words, the shorts are helping the regulators do their jobs. You can just think about Valiant, if you remember Valiant as an example, the largest publicly traded company in Canada at the time, lots of financial shenanigans, inflating drug prices, ultimately criminal charges. And where did all this start? It started with a short seller report published over a year before those charges, and the stock fell 30% on the report. Okay, so there are some other things in the paper. There's a description of executive and auditor changes and financial restatements. I won't go through all that detail. If you're uncontrollably excited about me saying that, that's a plug for the paper. I'll also just put in a plug for an annual conference we just had for our 5th straight year called Fraud Fest, which includes a lot of short sellers. And if you just go to berkeleyfraudfest.com, you'll see a lot of them. And a big debate involving Carson Block and Rob Jackson over Josh Mitz's work. So that's probably code to a lot of you. And you can hear sirens in the background. I promise you that's not them coming to get me for saying good things about short sellers. But those are the empirics. All right, just a few more minutes from me. on the policy implications. So the last part of the paper, like a lot of law review papers, goes through implications for policy and for the markets overall. So what should we take away from these findings that short activism is associated with such dramatic effects? And it might not surprise you, based on listening to me for 27 minutes now, that we see little justification for extensive regulation of short selling, particularly bans, in light of this long-term impact. If anything, it's an argument for relaxing regulation, or arguably even subsidizing short sellers. That this will be maybe the most controversial things that I'll say, is that if our paper is right and there are these long-term effects, that we really need these people. And to the extent they're disappearing, we should come up with ways to encourage them to come back. And one of the reasons for that is not just informational efficiency, that they make stock prices more accurate for all of us, and therefore should give us confidence in the capital markets and help lower costs of capital for companies, but also that they reinforce a kind of private attorney general role, that they're a filter for meritorious cases brought by private lawyers. And maybe we should explicitly recognize that. And for example, judges, when they're looking at cases based on stock price drop, could actually look at the stock price reaction or look at the reputation of the law firm or the short seller and say, this is relevant information about how truthful the information was. We also, as a policy matter, say regulators could embrace these short sellers and their announcements as a signal for investigations. They could forget about punishing these folks. They could have an informational filter where they would look very closely, kind of in the same way you'd look at a whistleblower when a short seller publishes a report, and maybe use that to start investigating a case. We have some other more controversial ones, just because law professors like to be controversial. So we suggest that boards of companies should get information from short sellers. So if you're on a board of a public company, you could once a year ask your top 3 short sellers to come in and just tell you what they think about the company. It'd be useful information for you to have to know what they think is problematic. And then finally, the two most provocative aspects are, and I'm not sure how seriously we take these other than just to provoke, but one would be to have investigative journalists fund themselves by short selling. So it's very difficult to be a journalist and to make money as a journalist now. So investigate a company, take a large short position in the company, make money off of it, maybe also engage in whistleblowing. And so that's one kind of controversial one. And the second controversial one is an approach we call short and strike. So for those of you who are fans of labor, labor could, rather than just being concerned about how the pie gets divided between employees and shareholders, could take a short position and then exercise their power as workers to strike when the stock price goes down. They have made money off of their short position. Okay, so that's as provocative as I get. But the basic point of the paper is to engage scholars and practitioners and policymakers in thinking a little bit counterintuitively, maybe about short sellers, and to shift away from what I think has become, in many fields at least, the presumptive skepticism about short selling. And so we want to suggest that maybe you should embrace these phenomena as being desirable, maybe intuitively unappealing. Sometimes free speech advocates are intuitively unappealing. Sometimes people who support our First Amendment rights in the US are normatively undesirable in some ways, but they're nevertheless central to the protection of important principles and policies. And so you might not instinctively side with these people, the negative activists, but their presence, we say, can be central to desirable policy results. Okay, so that's somewhere in the time I was allotted, I hope. And now I get to hit mute and listen to how wrong we are, or maybe how we're right a little bit, or somewhere in between. So Tom, it's all yours.
Thank you very much, Frank. Really fascinating presentation, and thank you very much for it. For the listeners, I'm sorry to disappoint in some senses before I've even started, but sometimes when we get back-to-back presentations, fireworks and conflict make for a really exciting presentation. Unfortunately, I would have to say that many of the things and many of the thoughts, suggestions, and observations from the research sit very true with our observations and the work that we've done at ASIC. I've got a couple of points I'd like to run through. And the first being, and really fascinating, I'll start with some perhaps responses to some of the observation from Frank's presentations. And what was really interesting was the focus of my discussions today will be primarily on the immediate to short term. And as a market surveillance manager, we look to ensure that markets are properly informed. So we need to deal with that question very quickly, and I'll come to those logistics in a little while. But what was really fascinating were the observations that the negative activism have a real and long-term effects on the share price. And thinking about what that means, to me, it would suggest that the issues that are being raised in many of these reports perhaps now portray a more accurate representation of the company's value. That is, they've raised questions by investors as to the value of that company. So I found that fascinating. And the issue that short sellers, as Frank noted, are finding good information. And it does go to a structural question around research and the predisposition of the research globally being around, buy, accumulate, and bullish research as such. Because from a business perspective, ultimately, broking houses, investment banks, and others that produce research, you spend a lot of time setting up models, hiring research analysts. And if your one research report is a sell report, your client base is out, that is the end of the report. But as we know, where there are companies which are covered positively and companies are growing, then there will be further opportunities for investment banking franchises, investment banking opportunities, etc. So there is value, we argue, in the short reports that are published, and as a regulator, provided it's being done lawfully. And I'll come to that in a little while. So the primary point is that we, ASIC, and not only ASIC, but ultimately it says in the Corporations Act, and we support this, that short selling is a legitimate mechanism for price discovery and liquidity. And it adds to, and the practice of activist short research adds to investors' information, as Frank's presentation has said. But it must be done legally. And this is where from a regulator's perspective, we want the activist short reports to be produced legally. We want the short selling to be done legally, but also the target companies to respond accordingly. There was a question, and it's probably a good segue to respond to the question which popped up during Frank's presentation, and it was specifically in relation to Australia, and have better continuous disclosure requirements led to less short sale activism in Australia compared to globally? Excellent question. Our research, and we drew a lot of our statistics from the Activist Insight publication, but I think the short answer, and it may be a little bit presumptuous and not entirely just based on statistics, but the short answer I would suggest is yes, because the numbers are very low. Of the cases that we saw in a period from 2010 to 2021, there were just shy of 1,900 cases globally of activist short selling. Of those, there were, at the time of publication, when we published our report, 25 cases in Australia. There have been a few more in recent months. So arguably, that's a very small sample size. And is this a bad thing? And again, it was really interesting, the opening comment that short sellers are the sworn enemy of management. Again, we believe there is a role for critical research. We believe there is a role for short selling in our market, provided it is being done legally. And I'll come to how we manage that, some of those legal challenges. But some of the things that are being called out in terms of that we've seen, and I'm sure that Frank and those watching this presentation will realise what sort of things are being called out. Things such as aggressive accounting treatments, aggressive asset valuations around illiquid assets or unlisted assets which are held. Complex corporate structures in and of itself, not a problem. However, if you combine complex corporate structures with aggressive accounting, etc., even when it comes to perhaps the granularity of assets under management, there was a company which is no longer listed, but was listed on ASX. It was subject to a short report. The company said it had $400 million of assets under management, significant, almost $500 million, but it wasn't even broken down what the asset class was, let alone what the underlying individual assets were. So again, we worked very closely, and we share this space around company disclosure with ASX, which is the market operator in Australia, and we worked with them, as we do with all cases of disclosure, to ensure that where possible, we can get more granular information from listed companies. So there's a lot of things that these companies and the activist short reports raise, which, as Frank pointed out, will be of interest to regulators. So we are entirely agnostic, where we need, not just want, but we need all parties to be acting lawfully. So the activist short sellers, if they are producing these reports, and this is where it gets really interesting from a regulator's perspective. So the reports we found will often shine a light on areas where other researchers or other research firms have not identified or not looked for those risks, be it opaque corporate structures, etc. But the activist short does. So as I said, we will work with the ASX, and going back to perhaps jumping back to the question that was raised, what do we expect of listed companies? So, and this is really important. This is where my focus perhaps on the immediate to short term. These short reports are often designed for maximum impact. So parties will generally establish the short position ahead of the report, surprise launch that report on the market, the share price will fall, they will look to repurchase their shares and make a profit. Now, ultimately, if that report is based on information, and this is where what sort of information is it? Often it's information where the companies they've interviewed former staff members, they might have interviewed competitors. They will look at a vast amount of info, they'll conduct surveys, they will look at a lot of information, and this mosaic theory is not unusual in research, but they will pull it all together. What they do, and in some cases they will use very emotive language, and we've used that and we've referred to that in some of our guidance. But this is the core challenge where people will suggest, why doesn't ASIC pursue false and misleading statements? Now, very often those reports will have emotive language, but what they contain is information and observations based on research done. But they will then make inferences and draw conclusions on, if you attribute this observation to the broader business model, then the fundamental value of the company should be a lot lower. But it is very difficult from a legal and from a regulatory perspective because you need to particularize what in that report is false and misleading. And so to actually pull those pieces out and what might be, so there might be a false statement, but in the midst of a 50-page report, a statement which is not accurate, but there is 95% of the report which seemingly has a reasonable basis, raises reasonable questions, makes it very difficult and challenging to pursue it. In saying that, we will pursue those producers of the reports if we can identify available evidence to satisfy that they have engaged in misconduct and market manipulation. Similarly, we will look at listed companies. We will ensure, and this is where we work with ASX, that they respond in detail to issues raised. And this is really important. So going back to the very the most important thing that we need to do as regulators is to ensure market integrity, to ensure markets are properly informed. So if we say the activist short sellers are entitled to produce their report, which they are, then that should be done in a certain way. So there are certain things that we've identified that companies, how they should be doing it. They shouldn't be they should always have a reasonable basis for what they're saying. They shouldn't drop these reports or publish them during trading hours, because what happens is the market is surprised. All they see is information in the activist short report. The listed company's not had the opportunity to reply. So, and we saw this quite recently. There was a company, Lake Resources, a lithium producer. There was a report produced by J Capital. They released that report outside of trading hours. The company then called a 2-day trading halt, considered the entirety of the report and responded in detail to that report. So from our perspective, yes, we get the report out there. The company responds to the report, provides a detailed response, and this is important. So the companies, and one which has engendered quite a bit of debate, but companies can't simply dismiss reports which have a reasonable basis. Let's say it's a 50-page report, and say the entire report is false and misleading and we don't agree with it. That is not going to cut the mustard for investors. That is not going to cut the mustard for regulators and supervisors such as ASX. So we expect companies to respond in detail. So I think this is a really fascinating area, as you can tell. I'm quite passionate about it. Is it a big issue? As I said, I mentioned the stats in response to the question. There aren't many of these cases in Australia. If we're talking about less than 30 over a period of 12 years, there aren't many. In many cases, those reports have raised issues for us, ASIC, to be looking at the listed company and having a look at, be that accounting treatments, asset valuations, and or disclosure. Similarly, we look very closely at every report to make sure that where we can see, do the reports have a reasonable basis, and is there something that raises any red flags for us? What I really enjoyed is some of the, and it's about sort of thinking out of the box. How can the investment community use this information? I loved Frank's suggestion, and this is not an ASIC endorsement. This is a Tom Bidener's comment. So of short sellers, those that hold short positions in a company, for a company to open its doors to say, hey, let's have the largest short sellers attend the board meeting. Tell us why is it that you are somewhat skeptical on our business model and hold the short position? And what is it that we can do, because it's in the board's and the shareholders' best interests to manage the company in the best interests of shareholders. And if there are short position holders that have concerns, then that would be, I think, a very frank and productive outcome. Whether it will occur, I don't know. So yeah, as we can see, I wanted to give the audience an opportunity for some questions. And as I said, in principle, we see a role for this, but provided it is being done legally. And it's a really challenging area to manage. There are emotions, and primarily from the target companies. But by and large, when we engaged with the broader investment community and fund managers, they did see that there was a role for activist short selling, again, provided it was done legally. So thanks for the opportunity. I found it a fascinating session. Thank you, Frank, for your presentation. And perhaps to throw it open, I think there are a few questions and it would be good to try and see between us if we can respond to those.
Fantastic. Thank you both so much. That really was fascinating. I particularly loved the concept of, the parallels between whistleblowers, because of course, whistleblowers are again that two-edged sword. Are they maligned or are they supported? And it's just this question of how do you get information from people who actually know what's going on? And in some ways, the UK now having employees, on the board or giving information to the board is again part of that picture. So just on that point of, are there some types of short selling that are positive, but some types that are negative? Mark Humphrey has asked this question, a regulatory question. Does ASIC have a position on people who are shorting a company, but then cause the price to fall, per Professor Partnoy's short and strike idea? Shorting and then taking action to harm the company's fundamentals strikes me as undesirable, as opposed to just producing information that Tom was talking about. So who wants to jump in first?
I'll perhaps respond on that. If ultimately the strategy that some of the activist short selling firms will employ is the element of surprise, but provided that report contains information, legitimate questions, and information with a reasonable basis, and is not false and misleading, it may well have a market impact. But arguably, we would suggest that that is a revaluation of a company based on that. It may be undesirable for the target company, but if it is not false and misleading, then I would argue it then creates a more accurate representation of value. And yes, they will profit from it. But again, if they've done the research and identified particular flaws or concerns in a business model, then I think it is reasonable to expect the producers of that research to be able to trade on the back of it. Again, provided it is done legally, and that is a really complex area and case specific.
And I'll have to disappoint the audience by saying that I very much agree with Tom's answer here. We'll try to find some way to mix it up, but I think you're absolutely right. And Mark's question is fascinating, and I just want to focus on one word that he uses, which is harm the company's fundamentals, right? So if what you're doing, as Tom says, is simply revealing information that leads the company's stock price to more accurately reflect what that company really is, well, you're causing harm to people who own stock, but you're not really causing fundamental harm to the company. Whereas I think the argument can be made more if you're striking, maybe you're fundamentally harming the company. On the other hand, maybe you're not. Maybe you're just equilibrating the relationship between labor, employees and management and the shareholders. There's an interesting example that we looked at in our first paper where Kyle Bass took short positions in companies that were heavily dependent on intellectual property and then undertook action to disable their patents. And if the patents then were disabled, the value of the company would decline. And that harms the company, right? Harms the company in some fundamental way as well. But it really does present a puzzle as to, again, this key word in Mark's question about harm. If it's the example of blowing up the bus of the publicly traded soccer firm, that obviously is social harm that we wouldn't ever want to happen. But if it's something more ambiguous, then it becomes harder. But I think I wholeheartedly agree with Tom that if what's happening from the short seller is mostly informational, this is why we had this distinction between informational negative activism and operational negative activism. It's hard to say that that's really harming the company, even though some people are losing money and some people are making money. It's a really great question.
Our next question comes from Neil Bromick from Listings Compliance at the ASX. He asks a sort of a natural justice kind of question. Should short sellers be required to provide the listed entity with an advance copy of the short report, giving them an opportunity to respond, rebuttal prior to being released to the market? What about that?
Short answer is yes. We have included that in our guidance. It is guidance at this point. It is not a legal obligation, but obviously if companies are not complying with our guidance, then we can consider their conduct more broadly and whether that would add weight to any possible legal breaches. But in short, we've suggested that activist shorts should be doing that and doing fact checking. Obviously, that's counter to their element of surprise. So we suggested, and if they don't, as I said, we'll consider the conduct as part of sort of any other adding weight to possible legal breaches.
That maybe we'll disagree a little bit on this one now, then, because I think in the U.S. at least, some people would have free speech concerns with requiring that kind of dissemination to the company management in advance. And although managers have a good sense of what sell-side analysts are going to say, as you mentioned before, by far the bulk of research analysts are on that side, and I think you're right to suggest there might be bias on that side. We don't have a similar kind of requirement, and I don't know if you have at ASIC a similar requirement for analysts who are publishing positive information to verify that in advance. We just recently, in the wake of a major Supreme Court case and an SEC rule in the US, have some litigation around this kind of requirement, or the idea that a proxy advisory firm would be required to share its vote recommendation with management in advance. And the SEC in the US just considered that. So it might be an interesting reference point. If you haven't seen that one, I'd be happy to share it with anyone on the call. But I guess I would just resist a little bit the asymmetry of the idea. If it is the case that you're treating short seller reports, analyst reports differently from long reports, and then also to say, well, why do we have this kind of prior restraint, right? We don't do this in other contexts. I mean, sometimes journalists will say, I'm going to give you the opportunity to comment, but it's not a requirement. Sometimes journalists need to spring the story when it's sufficiently important.
Yeah. Well, Frank, we had discussion in Australia last year about whether there should be constraints on proxy advisors, but it seemed to bite the dust. Alan Shaw, I think this question might overlap with one that we've already talked about, but he says, following up on one of Frank's implications, if workers do shorter stock and then strike and profit, could they not risk committing market manipulation? And if so, how could they legally use short selling? So
yeah, I can't speak to market manipulation under your law, but I'm not sure it's really, I mean, it's a provocative example of changing the stock price based on your own actions. But I think it's tricky to call it manipulation. I'd be very interested to hear if Tom thinks that it's clearly manipulation, or if there's some, if it's sort of potentially a gray area. And if it is, what if you don't actually strike, but you just announce, well, we might do this, but you're short? Does that make it more challenging?
I think in short that there is certainly a risk, as I sort of alluded to in a response to a previous question, and it does go to whether that publication whether that publication contains false and misleading statements. It is difficult because we would have to establish as I said, to particularize particular statements and isolate those. There was a case recently in Australia that was uncontested, and the court did find, because it was uncontested, that the statements by and large which were put to the court were accepted. It's not an easy area, and I point to the fact that there were literally, when we were looking for regulatory outcomes against activist short sellers, I mentioned there were 1,900 cases globally. I think we were able to find less than 6 cases against activist short sellers, which goes to suggesting just how difficult a process it is. But in principle, we would, would pursue it where we had necessary evidence, but it's really tough.
I'll just say parenthetically that the fact that there are only 25 cases suggests that you're doing a great job, right? That they're both are not situations where securities are so mispriced that short sellers think they can profit from it, and also not situations where short sellers might be able to intervene and manipulate the price in the short term. So I think you should, maybe we should get T-shirts that say only 25 cases or something like that. But I think it's in equilibrium, we would expect to see a relatively small number of these kinds of interventions if markets are appropriately reflecting information.
Yeah, I was thinking the idea of the workers shorting the stock, if only they'd known the possibility of that during the Enron collapse, you could have had a lot of happier workers. We've got 2 questions that relate to insider trading. Doug Clark says, strike and sell in Oz, that might be bordering on insider trading. And Elizabeth Boros from the Victorian Bar says, when you say provided it is done legally, is your main concern the possibility of misleading statements or insider trading? Well, I think we've dealt with the misleading statements bit, but I'd like to hear your views on the insider trading, and which has historically in Australia been rare as hen's teeth, but at times in the US, in the District of Manhattan, they were suing and succeeding in insider trading like crazy for a period.
Right. So the insider trading is a tough one under US law because you have to establish that there's a breach of duty to the source of the information. And typically, if it's your information, you're allowed to trade on it. Or if you obtain it lawfully without a breach of duty, you're allowed to trade on it. And so I think the tricky part in some of these cases that Elizabeth has in mind is whether or not there's a breach, whether there's a breach of duty. So short sellers, if they're just investigating on their own and obtaining information from their investigations, then it's hard. I will say the Department of Justice has a whole series of investigations happening right now, and we don't know the details of those, but it might be that they have some information and that we'll find out if those cases are ever brought. Maybe they do constitute insider trading, but you'd have to, at least under US law, you'd have to show that breach.
In Doug's question, I actually left off a coda that came in a second question in the Q&A, which was if the strike was not public. So he was really talking about non-public information. Tom?
It is a very complex question. And on the face of it, I think people, the inclination is to automatically assume that anyone with the particular short seller, it depends very much on what the information is. We can't simply look at the price impact and we would have to particularize the information. And then is that information, as we spoke about the mosaic theory, is that information generally available, readily observable when somebody has done research based on information in the public domain? It becomes particularly curly if you're looking to suggest that mere knowledge of the report, not what's contained in the report, the fact that activist short seller is going to publish a report on company XYZ. We would then have to conclude, and this is where legally, and I'm not a lawyer, it would get very curly to establish that every report published by that activist short seller will have a material market impact. And if it does not, then is simply knowledge that somebody will publish that report insider trading when only half of those reports have some market impact and not all of that is material. So they are, really super challenging areas, questions we're live to, both from a manipulation and an insider trading angle, but very much depends on defining and particularizing the information. Not a simple...
I agree. This is a fascinating area, and I'm imagining a final exam question I could write based on this now. But I'm wondering. So, under U.S. law, if a union, if a labor union were to start thinking about this idea, and were to give permission to employees to short the stock, that would likely not be insider trading. But if they said, listen, we're planning this strike and we want to be sure that no one does this, and then if you breached your duty as a union member and traded in the stock, then that likely would be insider trading. But it sounds like this is a sort of not very sensible way that the U.S. attacks insider trading, but it's just done so over decades historically. It sounds like you have maybe a more sensible approach.
Well, Michael Duffy's actually asked a question about insider trading and market manipulation, where he really makes that point about how Australia's laws, because it's sort of equality of information, are far broader than the US. But that's led to a lot of criticism of the Australian laws, that they are so broad that they can catch anyone, and that then takes the focus off the people who are most at risk. I don't know what you feel about that, Tom.
As I said, I'm not sure that I can agree entirely. And as I said, it's a non-lawyer for me to be opining on the ambiguity of our legal framework. I don't think I'll venture there, other than to say I think our primary concern is ensuring, properly informed markets. And I don't want to sound as though I'm singing from a hymn sheet, but really to work with our co-regulators, with ASX, really to ensure that companies respond to issues raised, and those that are producing reports, to make sure that those reports have a reasonable basis. But I really, as I said, I don't think I'm in a position to opine on the sort of ambiguity of our legal framework.
Sounds a wise move, Tom. And now we've got a question from John Kavanagh. He says, when a fund lends shares to short sellers, does this not seem like a breach of the fiduciary obligations of that fund?
So I think when you lend shares, you're lending them through your brokerage arrangement, and I don't know that you conceivably could be aware of information that a short seller would have or what their intentions would be. Typically, you're lending shares just to be able to capture 20 basis points or 15 basis points or something like that associated with your agreement with the broker. And so I don't know that you'd breach fiduciary obligations, but you can imagine if the fund had information, or that they knew who specifically would be getting the shares, that they might. But I think in the general case, if you're just, the way that I think of share lending, at least in US markets, is you're simply toggling a switch, either yes or no, in terms of being willing to lend your shares out. And then the broker will either lend them out or not, but you won't actually have any additional information as to where they're going.
Right. Sarah Delhunty's got a question here. If the short seller sells stock at a time that the short seller is aware that the workforce is going to strike, which is not generally known by the public, the own intentions defence does not seem to apply, as it is the intention of more than the short seller to strike. Probably that would be insider trading, wouldn't it? Tom?
Look, again, it would depend. Every case is different depending on who knows what the information is. I'm sorry it's a glib answer, but I don't think I could simply agree with a blanket statement based on that sort of set of facts. As I said, each set of facts is different depending on what they know, what the information is it generally available, etc. So I'm not trying to be evasive. As I said, just hard to give any kind of blanket, yet looks like insider trading. It's just, it always depends on the specific facts and circumstances of every case.
Frank, you're good on that one? Or do you want to say anything?
No, I think I agree that it's definitely context specific. I do think that this question illustrates for me how important it is to When you hear a question about short selling, ask yourself the mirror question about a long position and what your to test your intuition about the circumstances under which you would say, no, this is problematic for a long position. And I think we do, I very much agree with Tom in both. I think for long positions, when we think about these kinds of questions, we're very fact specific. So I think, no, I think you can easily imagine that the information that the short seller would have about the intentions would be enough. But that also could be true on the long side.
Okay, now we've got a question from Tom McCarthy. Tom identifies himself as a Monash Law alum. Welcome, Tom, who's previously worked in securities lending at a big super fund. And he asks the question, legally, is there any difference between a short seller, as how we've discussed it today, versus a journalist who shorts a stock just before they release a commercially critical piece?
Yeah, the answer in the US is definitely yes. And there are several high-profile cases of journalists going to jail or being prosecuted by the Securities and Exchange Commission civilly for that. But again, it goes back to this notion of who they've breached a duty to, because they didn't have permission from their employer to engage in short selling. Now, it does pose, so I've talked to people at several media outlets about the idea of giving their reporters permission to do this. And I think if the reporter has permission and is not breaching a duty to the source of the information, then I think the answer to Tom's question is legally there isn't any difference. But there is a difference because of the relationship that journalists have. Journalists are also bound by codes of ethics. So that can create another problem for journalists. I should say I've mentioned this to some Pulitzer Prize winning journalists, and they're absolutely horrified by the idea. So no one's planning to do this anytime soon. But I think, at least in theory, if you have permission as a journalist, there might not be any difference in terms of Tom's question.
You might lose your Pulitzer Prize if you do it. Tom, what about the Australian position for journalists?
I think in principle, if there's information asymmetry, and regardless, if we're talking about an insider trading question here, we're talking about, commercially critical. Do we read, I'm assuming we read that as material non-public information, comes back to what the journalist is saying and whether that material could be deemed inside information. And if it is and they are trading ahead of it, then I would imagine a journalist or any other market participant engaging in that conduct would be of interest to ASIC and their trading concerning.
Well, we've come to time. We could have talked for hours more, I know. This is a fascinating topic. I would like to thank Frank and Tom so much for this conversation. It's been fabulous. Thank everyone in the audience for coming to our Law and Business seminar today. And if I could just mention, do go to the Berkeley website and check out the Fraud Fest. I'm definitely going to be there as soon as this is over. That sounds a fantastic initiative, Frank. But also, if you could check out the CLARS website, the Centre for Commercial Law and Regulatory Studies website, you'll find that our next Law and Business seminar is on quite soon. It's on the 1st of September 2022. And it has Professor Neil Richards from Washington University, who is one of the world's leading experts on privacy. And he's going to be talking about why privacy matters with my colleague from Monash Law, Chris Marsden, as the commentator. So thank you, everyone. And we really hope to see you again soon.